an originating motion in the High Court, originating summons. That is, the plaintiffs are myself and Melissa Sasidaran, and the other plaintiff is Lawyers for Liberty. So the three plaintiffs are Lawyers for Liberty, myself and Melissa. Myself in my capacity as advisor to Lawyers for Liberty, and Melissa in her capacity as the director of Lawyers for Liberty. Now, we have sued as defendant Mr. K. Shanmugam, who is the Minister of Home Affairs for Singapore, right? And what we are seeking in this originating motion is for a declaration by the Malaysian High Court, by our High Court, that the order issued to Lawyers for Liberty, myself and Melissa, that we post a correction notice on our earlier statement, failing which that correction order was issued by the Singapore government, and they have said that failing which we will be guilty of a criminal offence under the POFMA, which is the Prevention of False Suits Act of Singapore, an act passed under great controversy, as you all know. And we have also asked for a declaration that the defendant, that is the Singapore Home Minister, Mr. K. Shanmugam, cannot take any action against us in Malaysia under the POFMA. Okay, we filed it with the supporting affidavits, and of course we'll be awaiting for a hearing date.
Now, we have sued the Minister for Home Affairs. This case raises some very interesting, novel questions. The question is, generally speaking, sovereign states and their ministers have immunity from being sued in the courts of another country. But in this case, what they are seeking to do has very serious consequences for our clients, because they have threatened that if the direction given by the Minister for Home Affairs, Singapore, if the correction is not done, then they are liable to be charged in the Singapore courts and be exposed to a very hefty fine, as well as a 5-year imprisonment term. And they have the ability to enforce under our reciprocal arrangements between the Singapore and Malaysian government. They can issue warrants and so on and so forth. So our clients are at very serious risk. Now, they have sovereign rights, but when it affects the fundamental human rights of citizens of this country, then the court has to consider whether there is an overriding public policy that will override their claim to sovereignty. So that is one of the issues that will be canvassed. And especially since the Anti-Fake News Act in Malaysia has been repealed. So now, by the back door, the Singapore government is seeking to enforce what our government has repudiated through this. So these are the issues that we want to be ventilated and decided by our courts, whether the courts can stop this kind of action from happening. Now, they may claim immunity, but we are hoping that the minister will be gracious enough, if he has the principles of the rule of law in mind, right, to waive any such claim to immunity, to have this matter adjudicated outside of the Singapore courts in a neutral country like Malaysia itself, where our citizens are going to be affected. And it will also have a very serious impact on freedom of the press, because anything that you say, you are entitled, for example, under the Reynolds principle, not to be sued even for defamation if you can justify the fact, even if what you report is not accurate, provided you have done due diligence in your reporting. So this will also affect the freedom of the press in this country in being able to carry out your journalistic vocation.
I think it really proves that what our government did in repealing our act was absolutely correct, because the oppressive nature of this legislation is clear for all to see. And I think the point that Dr. Budaya made, which is about the press, where you may write an article about Singapore. They don't know. They can clearly also use it back. They may not do it, but they can, and which is why it is imperative that this issue is decided by the courts.
I think that late last night they issued an order through their, I think their equivalent of our MCMC, their Information Ministry or whatever it is, in order to do the necessary to block our website. Of course, we find this very disappointing because from day one, we had written to, before we even revealed the details of how they were using the boot to break the neck, we had written to them and offered to give this evidence over to them privately so that something can be done about this method of execution. We had also issued public statements saying that we were willing to cooperate with the Singapore authorities to put an end to this practice. They ignored and they did not respond to our attempts, which is why we felt compelled and we had no choice but to go public with the method of execution. And now they also decided to block our website and such things. So it seems to me that unfortunately the Singapore government is more interested in silencing us and keeping the lid on this on the truth about the method of execution in Changi Prison, rather than getting to the truth of what is happening and take action. If the higher ups were not aware of this, then they should take action against anyone who is doing this and put a stop to it. We do not know what is the state of their knowledge, but blocking the website is part and parcel of what they've been trying to do, which is merely to silence us.